The next court case that we are going to discuss is the Tinker versus Des Moines court case. Now, this court case deals, again, with freedom in school. And in this case, we're talking specifically about freedom of speech in school. Now, during this video, I'm going to review the questions, and then I'm going to read the article, and I will take breaks while I'm reading to explain some parts of this case to you guys as I'm reading. The first question: why did the Tinkers and the Eckharts wear black armbands to school? Just so you know, this question has to do with symbolic speech, which is speech that is through a symbol or something that maybe represents an idea. And we'll maybe take a look at some ideas of what symbolic speech looks like. Question number 2. One important fact in the Tinker case that this article did not mention was that wearing black armbands to protest the Vietnam War was the only political speech the school district did not allow. The school district allowed students to wear political campaign buttons and other recognizable political symbols. How might this fact have influenced the Supreme Court to decide in favor of the Tinkers and against the school district? So this is a great example of a question that we have to keep two things in mind when we're looking at a question like this. One, it says that there's nothing in the article about it, which means that you're still going to have to answer it, but there's not going to be the need to put quotations from the article to answer question number 2. This is another example of a longer question, and in this question, we're dealing with a particular time period again. We're dealing with the Vietnam War. So we do have to have a little bit of understanding that during the Vietnam War, the country was not at an all-time high of patriotism, like in the other court case during World War II that we were reading about. During World War II, the mass majority of the population was supportive of the government and supporting the effort to win the war. The Vietnam War was very, very different. During the Vietnam War, the country was split on whether or not we should be there or not. It was not supported by the majority of the country, and that near the end of the war, particularly, the majority of the country wanted us out of Vietnam. Question number 3. In his majority opinion, Justice Fortes wrote, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." Explain what he meant. Justice Fortes is a Supreme Court justice. He was on the majority side in this court case. And the quote that is listed here, you probably want to break into 2 parts when you're answering it and explain those 2 parts. Question number 4. Justice Fortes also put 2 limitations on the students' free speech rights. What were these limitations? Now, it was very specific in the article about what these 2 limitations were, about what limitations students had when it came to free speech, meaning students can't just say and do anything in school that they want. There are rules, and these 2 limitations are still applied today in public schools. Question number 5. In his dissent, meaning the losing side of this court case, Justice Black wrote that this judgment subjects all the schools in the country to the whims and caprices or impulses of their loudest mouthed but maybe not the brightest students. It had been almost over 50 years since the Tinker judgment. was Justice Black right? So in other words, did giving students free speech, like wearing black armbands to school to protest the war in Vietnam, did that decision ruin public education? Did it make it so the loudest mouth students were able to or are able to disrupt class in a way that learning no longer happens? So Justice Black was saying, if you decide the way you did today, you're going to ruin public education. Was he right? Question number 6. Do you believe, and this is a question to you, to each student, do you believe middle school students, Mary Beth Tinker was 13 at the time of this incident, have strong enough political opinions to need to express them in school? Explain or provide examples of political issues in which students might be involved. So, in your opinion, do you think students should have the right to express political opinions in school? And if so, what political opinions are important enough to talk about in school? Now, I am going to point out one thing here at the top. It says questions for review. Answer 4 of 6. Must answer questions 3 and 4. Okay? So now I'm going to read the court case for you guys. If you would like to pause the video and take a break for a minute, feel free. But I'm just going to continue to talk about this court case. You'll notice that they're at the top, 393 U.S. 503, 1969. That means that the year that the case was decided was in 1969, and the court case number for this was 393 U.S. 503. The vote was 7-2, meaning 7 justices voted in favor of the students, and 2 justices voted against the students. For the court, which means Justice Fortes wrote the majority opinion. The concurring or the agreeing opinion are by Stewart and White. So concur means to agree. And you'll notice that not all 7 of the winning justices wrote an opinion. Only Fortes, Stewart, and White wrote for the winning side. On the dissenting side were Harlan and Black. Now, both of these Supreme Court justices, you'll notice, did write dissenting opinions, meaning disagreeing opinions. So let's give this thing a shot. In December 1965, some students in Des Moines, Iowa, decided to publicly express their opposition to the war in Vietnam by wearing black armbands. Des Moines school administrators, however, decided upon a policy that forbade the wearing of a black armband in school. Students who violated the policy would be suspended from school until they agreed to comply with the policy. Now, why would these students choose to wear black armbands? Back in the 20th century, a black armband would be worn to show mourning, meaning you are showing respect for someone who had died. So the wearing of a black armband might be something that people would wear to a funeral of someone that they knew. A lot of times black armbands would be worn by the pallbearers, the people who might be carrying the casket at the funeral. And so these students were wearing black armbands basically to mourn the loss of life in Vietnam, both American loss of life, the soldiers, and the Vietnamese soldiers and civilians that were killed during the war. Now, one thing that you should notice, you're not going to be asked about this, but one thing that you might want to notice is that this actually happened in 1965, and it took until 1969 to get to the Supreme Court. So from the act of protest in school that these students, and we'll get to them in a second, but the Mary Beth Tinker and Christopher Eckhart, they protested in December of 1965, but it actually didn't get to the Supreme Court for them to decide on until 1969. Okay? So we're going to read the next paragraph now. On December 16th, Mary Beth Tinker and Christopher Eckhart wore armbands to school. John Tinker did the same thing the next day, so that John was Mary Beth's brother. As a consequence, the three students were suspended from school and told not to return unless they removed the armbands. They stayed away from school until the early part of January 1966. So they missed probably, maybe a week of school, and then they went back to school after that, after their parents and their families hired lawyers and worked to try to get the students back into school. Next paragraph. The three students filed a complaint through their parents against the school officials. They sought an injunction to prevent the officials from punishing them for wearing the black armbands to school. The word injunction means kind of like it does in sports as far as a timeout. So what the families of the Tinkers did and the Barnetts did is they said, hey, can we let the courts decide on this? But until they make a decision, can our children come back to school? Next paragraph. The issue. And here's the big question, right? Did the school district's policy prohibiting the wearing of black armbands to school violate the students' First Amendment right to free speech as extended to the state through the Due Process Clause of the 14th Amendment? It's a pretty big question there. That's not something you have to answer directly, but it is something that you want to be aware of. Opinion of the court. The court decided by a vote of 7-2 that the students' right to free speech under the First and 14th Amendments to the Constitution. In previous cases, such as Stromberg versus California, the court had rules that First Amendment speech rights were incorporated by the Due Process Clause of the 14th Amendment, which provides that no state shall deprive any person of life, liberty, such as free speech, or property without due process of the law. So basically, the school had violated the fundamental rights, in this case, free speech, of these students by not allowing symbolic speech in school. And the school district had made a mistake and committed a civil rights violation against these students. And the students and their families took it to court and they won. Now, this is where you're going to get a fair amount of your information for some of your questions, so you should try your best to pay attention to this paragraph. Justice Abe Fortes wrote the majority opinion, in which he stated that the wearing of black armbands to protest the Vietnam War was a form of symbolic speech protected by the First Amendment. Therefore, a public school ban on this form of protest was a violation of the students' right to free speech. As long as the protest did not disrupt the functioning of the school or violate the rights of other students. Justice Fortes wrote, First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Now, this right here is a quote that you will have to explain what it means, and I'll do that now. Basically, what Justice Fortes is saying is, in school, students and teachers have the same rights, the same fundamental rights that they do outside of school. And when students and teachers come to school, it doesn't mean that they should shed their constitutional rights, or in other words, take off their constitutional rights, take off their fundamental rights as they enter into the schoolhouse gate. Because you come into school does not mean that you lose your rights. Now we're going to hear from the dissenting side, which was the losing side. And we're going to hear some quotes by Justice Hugo Black. Before I do that, though, I do want to backtrack a little bit. You are going to have another answer in this paragraph, and it's a pretty important one. It's the limitations on what free speech is in school. There are limitations. So here are the two different guidelines that schools have to use when they decide whether student speech is acceptable, meaning constitutional speech, or it's not acceptable speech, meaning it's not practicing free speech in the way that symbolic speech was in this case, where they were giving a political opinion. If the speech did not disrupt the functioning of the school, okay? For instance, if a student continues to stand up in the middle of class and yell profanity, well, it's hard for someone to get an education. It's hard for someone to teach. If there were outbursts where someone was swearing during class. So as long as the speech does not disrupt the function of school, as long as people are learning, as long as people are being allowed to teach, then it should be considered free speech. The other limitation is it can't violate the rights of other students. Other students have rights. If the speech is suppressing or taking away the rights of other students, then that could be limited. Okay? Now, another thing that this does not disrupt the functioning also has to do with making students feel safe. It also has to do with following laws that apply in school that may not apply outside of school. For instance, if a student is wearing a t-shirt and on that t-shirt it says, I smoke marijuana, that's a problem because schools are supposed to be drug-free. You can't even be near a school in possession of drugs or alcohol because it is a crime. You cannot promote a crime like consuming something like marijuana or alcohol in school. If you wore a t-shirt that had the name of a beer or liquor company on it, that would be against school regulations because it is a drug-free environment. By promoting alcohol or marijuana or another drug, that is a violation of the rules of school. That is disrupting the functioning of the school. Okay? So there are limitations. They are supported by the Supreme Court. And students do have rights, but it's about when and where and how those rights are practiced. Let's go back to the dissent. While I have always believed that under the First and 14th Amendments, neither the state nor federal government has any authority to regulate or censor the content of speech, I have never believed that any person has a right to give speeches or engage demonstrations where he pleases and when he pleases. And actually, this is something, I'm just going to stop reading for a second here. This is something that is true. Mr. Clifford cannot go into the middle of a city council meeting while the city council is meeting and start yelling at the city council members and tell them what I want to tell them by not following the regulations and rules that exist in a city hall meeting, I will be arrested and removed from City Hall if I am disrupting the function of City Hall. So he is correct in this, and this is a long respected thing, that you can't always go into any place you want to practice free speech. And he even says here, this court has already rejected such a notion. So in other court cases, they've basically said, it's clearly you can't just say whatever you want to say, whenever you want to say, at any location. Let me keep reading. One does not need to be a prophet or the son of a prophet to know that after the court's ruling today, some students in Iowa schools will be ready, able, and willing to defy their teachers in practically all order. This case, therefore, wholly without constitutional reasons in my judgment, subjects all the schools or the public schools in the country to the whims and caprices of their loudest mouth, but maybe not their brightest students. In other words, he's kind of insulting public school students by saying, if students are given free speech in school, they will use that speech to prevent learning from happening and to disrupt school in a way that it will ruin public education. Now, the question that you're being asked on the list of questions is, it's been 50, 60 years since he said this. Is it true? Did this decision to allow students to wear symbolic speech to school lead the way or pave the way or create a future that schools are no longer functional because there's so much disruption by their loudest mouth, but maybe not their brightest students? And again, that's an opinion question. Now, we're going to go into this last piece here, significance, meaning why was this case so important? And it really was. If you go to law school, you'll be studying this case in the first and second year that you're in law school. You can ask, if you know anybody who's a lawyer or judge about this, you ask them about it, and they'll probably remember something about this case. So the significance of this case. Tinker is one of the most important cases in the constitutional rights of students in public schools. It supports the protection of free expression that does not disrupt the educational purposes of the school or violate the rights of other students. In subsequent cases, meaning in cases after this case, involving students in public schools, such as Bethel School District number 403, which is actually Bethel, Maine, versus Fraser in 1986, and Hazelwood School District versus Kuhlmeier, 1988, the court supported the power of public school officials to limit free speech or limit freedom of expression by students if such expression in these cases of vulgar speech, the first one in Bethel, and the publication of sensitive material in this Hazelwood School District in the student newspaper disrupted the school's educational mission. So, court cases since the Tinker case have generally reduced free speech in school, limiting the amount of freedom that students have when it comes to free speech. And again, one of these, the Bethel School District one, from what I remember, had to do with a student running for a school committee, maybe class president, and swore during the speech, and the school prevented the kid from running for president and suspended the kid. The parents fought against it, but the school district won because the court said that was not acceptable for a student to be using profanity, foul language in their speech while running for class office. And the other one, Hazelwood School District, this one I believe was about a school newspaper where students had printed private information about some of the teachers that was very embarrassing to the teachers. And the school district shut the paper down, or maybe suspended the editor, or did something like that to stop it. And the parents and the student fought against the school, but they lost as well. So these two cases show how the courts can actually find ways to limit free speech in school. Even though the Tinker case was a very important case, because it actually set the boundaries that when it comes to free speech, students can practice symbolic speech, students can say what they want, but it has to be done within these two rules, meaning it can't disrupt the educational purposes of the school, and the free speech can't violate the rights of other students. So one thing I want to say about this, the article and the questions are both going to be on Google Classroom. And you'll notice in the article, if you scroll down further, we also have the article in Portuguese, French, and I believe Spanish. So if anyone would like to tackle them in any of those languages, that would be great. It looks like we have Spanish in here twice. Cool. So that is the Tinker versus Des Moines Independent Community School District versus Tinker. And I hope you guys enjoy this case. If you have any questions, feel free to contact me. I want you guys to take your time with this. We're not going to have to hand these answers in for these questions for another couple weeks. So I'm putting this up now so that you can watch the video and start the article and start the questions, but not really get rushed through it. Those of you who haven't started the process with the West Virginia versus Barnett case, I would suggest that you do those questions first and watch those videos first, and I think that they'll be very helpful for you. I am going to create another video for each of the questions, for question 1, 2, 3, 4, 5, and 6, just to show you how to answer it and just to give you some hints. But those videos I'll put up a little later. I want you to listen to this video and review the questions first, and then I'll start putting video questions or help questions out for 1, 2, 3, 4, 5, and 6. Again, I hope you guys found this video helpful, and thank you for checking in.